All right, good morning. We're on the record today from the 28th Circuit Court here in Wexford County, and we're going to begin today's docket call on the record with people of the state of Michigan versus Brandon Michael Syas. This is file number 25-14000FH. Appearances, please.
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Brandon. He's next to me at the table.
Very much. Court order, I have an exhibit sticker. We're here today for a final pretrial conference that was conducted earlier in chambers between myself and counsel. Counsel informed me that they anticipate the entrance of a pretrial agreement on the record today. Ms. Carey?
Thank you. It's my understanding the defendant will plead no contest to an attempt arson in the third degree. The reason for the no contest plea is civil liability. And count one will be dismissed.
Thank you. Mr. Harrison?
That I concur with that statement, Your Honor. That is my understanding as well.
All right, thank you very much. All right, Mr. Syas, is that how you wish to resolve today's file, sir?
Yes, sir.
All right. To the best that you can, I understand that you are in custody, but please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
I swear.
Thank you. Sir, you may lower your hand. All right, Mr. Syas, we're going to enter a plea today here, but I'm going to go over what the agreement is, what your rights are, and then we'll get to the plea. Looking back on January 7th of last year, it's been already over a year. Were you on probation, parole?
No, sir.
Good, thank you. Were you on bond at that time, pending any other felony charges?
No, sir.
You are currently charged on a piece of paper that's called a felony information. And on that piece of paper, you're charged with a single count. That count is second degree arson. And that is a felony punishable by up to 20 years and or up to $20,000 in fines and costs, or 3 times the value of the property damaged or destroyed, whichever is greater. I'm told today that that charge will be dismissed if you enter a plea of no contest to, and I accept that plea to, an added count 2. That added count 2 would be attempt arson in the third degree. Now, arson in the third degree itself is typically a felony punishable by up to 10 years plus similar fines and costs. However, an attempt of that would be reduced down to a felony, but punishable by up to 5 years instead of 10 years. And of course, instead of the $20,000 that we talked about earlier for the current offense. You understand that?
Yes, sir.
All right. Just realized I probably need to look up, well, I can easily determine the maximum punishment sentence with confinement. I want to take a look here at what the fines and costs are. I'm certain that there's the 3 times value of the property damaged or destroyed, but I do not know what the actual potential fine could have been. So one moment. Okay. For arson in the third degree, there's actually a couple different types of arson that could count. For instance, it can include the burning of a building. It can also include burning of personal property having certain values. And the reason why I'm stating this out loud is because when the prosecutor prepares the amended felony information, I want to make sure that they know which exactly one the court's going to use today. That is MCL 750.74 parenthetical 1 subparenthetical small a. Now, again, I told you that would be punishable by initially as a third degree. It would be punishable by up to 10 years and or up to $20,000 or 3 times the value of the property. However, as an attempt, which is what you're pleading to today, the maximum punishment would be up to 5 years and up to $10,000 or 3 times the value of the damage of the property. So far, is that what you understood you were doing today?
Yes, sir.
Now, by entering a plea of no contest, it has the same effect as a guilty plea. The difference is that instead of requiring you to tell me what you did, I'm going to look at a police report or an exhibit that the prosecutor is going to give to me and that you are going to agree that I get to look at. You understand?
I understand.
Now, I can take a no contest plea in a couple situations, and one of them is when a person could face potential civil liability, which means you could be sued for it as well.
Gotcha.
And that's what they're telling me the basis is for it today, so I can accept that. But here's a key fact. When you plead no contest and I look at an exhibit, whatever this exhibit says, it's going to be interpreted as the truth. Do you understand that?
Yes, sir.
All right. Now that's important because when we come back later on for sentencing, if I accept the plea, whatever's in here, you don't get to challenge. Do you understand?
Yes, sir.
Okay. I just want to make sure you understood it. Now, by entering this plea of no contest, if I accept that plea, you're going to be waiving certain rights. And that includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you're to choose to testify. Mr. Syas, do you understand those rights?
Yes, sir. I understand.
And even more importantly, do you understand that if you enter a plea of no contest and I accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes, sir. I agree.
Additionally, any appeal as the conviction and sentence pursuant to this pretrial agreement would be by filing what's called an application for leave to appeal and not an automatic or claimable appeal by right, which is only guaranteed or allowed when you are found guilty or a person is convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Do you understand?
Yes, I understand.
Now, before I go to the next step, and even though I know it's a bit redundant, I like having these advice and rights forms because it just ensures that there's a couple different ways you're getting informed of all your rights. I'm holding a copy up for you to see. Is that your signature at the bottom?
Yes, it is, sir.
Did you read through this before signing?
Yes, I did.
Did you understand what you read?
Yes, I did.
All right, thank you. Other than the pretrial agreement terms, have there been any other promises, threats, coercion, duress, the force or get you to plead guilty that we haven't talked about?
No, sir.
So therefore, you enter the plea of your own free choice?
Yes, sir.
Now, Mr. Harrison's probably gone over sentencing options and ideas and possibilities for you. They generally do a very good job at it. You've probably gone over something called the Michigan Sentencing Guidelines, where there's a chart and they score different guideline ranges for judges. I want to highlight for you that whatever he's told you is an estimate because we don't know exactly what those guidelines will be. You understand?
I understand.
Now, those guidelines, no matter what they are not mandatory upon the court. The court is required to use them, but their actual result is not mandatory. Kind of odd to say it because if a judge ever goes outside of the guidelines, the appellate courts will normally look at them with a fine tooth comb, but I just need you to make sure that there's nothing out there that you think you're going to get an exact sentence. Is that right?
No, I do not know.
All right, fine, good enough. And I just want you to make sure. Thank you very much.
Thank you so much.
Sir, do you still intend therefore to enter the plea of no contest as to the added count 2 of attempted arson in the third degree?
Yes, sir.
As to that added count. Remember, I know I expected to be no contest. I'm not telling you what to say, but normally when I ask this
Right.
question, even though I've gone all over the differences, people always still say guilty. Therefore, as to the added count 2, how do you plead?
Guilty.
Oh, no, you just did it. It's all right. Remember, I expect you to plead no contest.
No contest. That's
There you
right.
go.
That's right.
All right, I'm not accepting the guilty plea, therefore that cannot ever be used against you. Now we're gonna look at the no contest.
Thank you.
I have before me what is marked as plaintiff's exhibit number 1. And Mr. Harrison, the prosecutors presented it to me for consideration. Mr. Harrison, any objection?
No, it was with my agreement that we did so.
Thank you. The council gave you this in chambers.
Yes.
People's exhibit number 1 is hereby admitted. I'm going to say that these are all collectively referred to as exhibit number 1. There are individual reports. The first report is a Michigan State Department of State Police file number, incident number FIU, which is Fire Investigation Unit 8-25, and it consists of 10 pages plus looks like a forensic report request at the back. Also is Michigan Department of State Police incident number 71-6625, which is a report by the Michigan State Police Department. It consists of an initial report with a couple supplements I see here at the back. Next is a Michigan State Police Department report, incident number 71-65-25. It consists of only 3 pages. And then there's an additional supplement here. One moment. In that first portion of this exhibit, I referenced the initial incident report. And I said there were some supplements. I should have been more specific. It skips from what would be supplement 1 and 2 right to supplement 3. Well, the third portion is supplement 2. It's actually separate for some reason, which is okay. That is again for incident number 71-66-25. Also behind that are some forensic reports from the forensic lab in Grand Rapids, and a photograph behind that of what looks to be a lighter, a shotgun shell, and the spout for a gasoline can. Ms. Carey, do you believe that the interests of justice permit the court to accept a no contest plea?
Thank you, I do.
Mr. Harrison, do you agree?
Well, I concur wholeheartedly.
Ms. Carey, do you believe that the information in these reports that are a part of People's Exhibit number 1 satisfy the required elements for the added count 2?
I do.
Mr. Harrison, do you
I
agree?
agree, yes.
Carey, are you aware of any other promises, threats, or inducements of which we have not discussed?
I am not.
Mr. Harrison?
But I am likewise unaware.
And Ms. Carey, do you believe the court's compliance with Michigan Court Rule 6.302?
Yes, sir.
Mr. Harrison?
You have.
Thank you. The court agrees that the interest of justice based upon potential civil liability will allow the court to accept a no contest plea. The court further finds the plea today has been made freely, knowingly, and voluntarily. The court further finds, because I've reviewed all this information in People's Exhibit 1 before taking the bench, and that it contains information that would satisfy the elements for the added count 2. Specifically, in the initial report from the Fire Investigative Unit of the MSP, there's information that Mr. Syas was staying at the residence, that he went, borrowed a gasoline can, went into the residence, came back out of the residence. I think his sleeve was on fire. Fire was beginning to build inside the residence. There were some statements that would lead to perception of an ignition. There was testing done. He had smelled of gasoline and so forth. Therefore, the court accepts the plea, finds the defendant guilty of count 2. All right, Mr. Syas, that means that we're going to be back in about 4 to 5 weeks. Between now and then, an agent from the Michigan Department of Corrections, which is also known as a probation and parole office, is going to prepare what's called a pre-sentence investigation report. Now, this report will describe to the court what happened in terms of the agreement, any information you make or provide to them, and when you fill out that report, It will include a scoring of the guidelines, which again are not mandatory. It will even have a recommendation as a sentence. That recommendation is also not mandatory, as it is the judge alone who determines the sentence. It will also include information about any prior criminal history you have, any other performance issues such as on probation, parole, or well, it should have been parole because I didn't see any habitual enhancements, but performances on bond and so forth. Okay, one moment. After you fill out this report and turn it back in, you'll be subject to an interview with an agent from that office. You have the right to have your counsel present during that interview. And third, Mr. Harrison's going to have to meet with you prior to coming back for sentencing, because one, you need to know about what it says, because each side has the right to object to the contents, object to the scoring, request corrections, and we need to make sure that whatever is in it is complete and accurate. That even applies to any prior criminal history, right? While I think we've got probation officers who do a really good job preparing the reports, whoever may have entered criminal histories before, they may have done it incorrect, so forth. So I don't like to pass along somebody else's mistake. So I need to make sure those changes are there. Any questions about what we have done yet today, Mr. Syas?
No, sir, you were thorough and adamant about everything. I appreciate you.
All right, good enough, sir. Thank you very much. Ms. Carey, anything further on behalf of the people?
Did you have a DNA order?
All right, I'll sign that. Mr. Syas, whenever someone's convicted of a felony in a state court in Michigan, not only must there be that PSI prepared that I mentioned, for the first time they're convicted, there must be a DNA test taken. Now that test is just simple. I'm sorry, I said test taken, a swab collected. That's just a swab from inside your mouth, really uninvasive. They'll do it for you over at the Wexford County Jail. All right. Thank you. I have signed that. You're going to get a copy of it. Your attorney will get a copy. All right, Mr. Harrison, anything further on behalf of the defense?
I have nothing further, Your Honor. Thank you.
Thank you, folks. We'll see you shortly.
Thank you, sir.
Thank you. Ms. Carey, your exhibit, ma'am?
Yep. Okay, you got it?
Yeah, that needs to go.
Yeah.